नमस्कार दोस्तों, मेरा नाम श्रीनिवास एडवोकेट है। जिस विषय पे मैं आज बात कर रहा हूँ ये पेरोल यानी रिलीज ऑफ एक्यूज वन हु इज़ कन्विक्टेड इन एनी क्रिमिनल केस आफ्टर ट्रायल इज़ कंक्लूडेड एंड जजमेंट इज़ प्रोनाउंस्ड। लोगों को कन्विक्शन होता है कई केसों में। कन्विक्शन होने के बाद जब वो जुडिशल कस्टडी में रहे या कन्विक्शन इम्प्रिजनमेंट है जेल में, तो जेल में रहते हुए अगर किसी कारणवश उसको बाहर जाना हो, अर्जेंसी रहा, इमरजेंसी रहा, जैसे उनके घर वालों का तबीयत ख़राब हो, सीरियस हो, नहीं तो घर का खुद की प्रॉपर्टी का कोई डिस्प्यूट हो, बहुत सीरियस मैटर हो, ऐसे कई सीरियस इमरजेंसी मैटर्स में तो एक्यूज जो कि कन्विक्टेड है पेरोल पिटीशन फाइल कर सकता है। ये पिटीशन सुप्रिटेंडेंट ऑफ जेल अथॉरिटी यानी जिस जेल में उन्होंने कैदी है उस जेलर को वो एक रिप्रेजेंटेशन देते हुए कि मेरे को पेरोल चाहिए, पेरोल पिटीशन फाइल करके रिक्वेस्ट कर सकता है। तो प्रिजन एक्ट जो है, प्रिजन रूल्स के तहत ये पिटीशन फाइल किया जाता है। जब कोई आदमी कन्विक्टेड है और जेल में है कैदी की तरह, वो भी कर सकता है। और जो आदमी कन्विक्शन नहीं हो के केस ट्रायल में है, इज़ अंडर जुडिशल कस्टडी फॉर सेवरल मंथ्स टुगेदर, जब बेल ना हो, जुडिशल कस्टडी में ड्यूरिंग कोर्स ऑफ ट्रायल रहे, तब भी फाइल कर सकता है। तो पेरोल एक्चुअल क्या है, इसके बारे में अगर अपन जानकारी लें, पेरोल इज़ नॉट ए सस्पेंशन ऑफ द सेंटेंस, द कन्विक्ट कंटिन्यूज टू बी सर्विंग द सेंटेंस डिस्पाइट ग्रांटिंग ऑफ पेरोल अंडर द स्टैट्यूट। तो पेरोल क्या कहता है? अकॉर्डिंग टू लॉ लेक्सिकन, पेरोल हैज़ बीन डिफाइंड एज ए पेरोल इज़ ए फॉर्म ऑफ conditional pardon by which the convict is released before the expiration of his term to remain subject during the remainder thereof to supervision by the public authority and to return to imprisonment on violation of the condition of the parole। तो ये है पेरोल। तो पेरोल में जो आदमी कन्विक्टेड है उसको अपने इंडिया लॉ क्या कहता है पेरोल के बारे में? पेरोल के बारे में इंडियन लॉ कहता है देयर इज़ नो यूनिफॉर्म लेजिस्लेशन for granting parole in India. Each state has its own set of parole guidelines which may differ from one to another state. Prison Act 1900 and Prison Act 1894 are the main legislation that governs prison rules and law in India. The Act has empowered the state government under Section 59, Clause 5 of the Prisons Act 1894 to enact regulation for the management of prisons. Since prisons falls under the state list of the 7th schedule of the Constitution, the state government may enact laws for the regulation of prisons. ये प्रिजन के बारे में, पेरोल के बारे में इंडियन लॉ कहता है। अब रहा इंडियन लॉ पेरोल के बारे में जब बोल रहा है तो कौन कौन से जजमेंट्स है या कौन कौन से स्टेट में, किस स्टेट में किस तरह का रूल्स है विद रिगार्ड टू ग्रांटिंग ऑफ पेरोल और कंसिडरिंग और रिजेक्टिंग द पिटीशन ऑफ पेरोल। इसके बारे में कई विदेशी कंट्रीज़ भी बहुत बार ह्यूमन राइट्स के बारे में बात करके कई इश्यूज़ है विच आर स्टिल पेंडिंग बिफोर कंट्रीज़। पेरोल इज़ ए कंसिडर्ड ए राइट फॉर प्रिजनर बाय ए नंबर ऑफ इंटरनेशनल courts and organizations. For example, the European Court of Human Rights has created extensive jurisprudence on the subject of parole, as some justices feel that an irreversible life sentence, life without the possibility of parole, would be in violation of the norms of the human dignity. अपना इंडियन सुप्रीम कोर्ट क्या कहता है इसके बारे में? सुप्रीम कोर्ट डिसीजन अशफाक वर्सेस स्टेट ऑफ राजस्थान 2017 sheds some light on the Indian's parole law. The court in this case observed that parole is the conditional release of a prisoner based on good behavior and the need that the prisoner report to the authorities on regular basis. It is simply a postponement of sentence for a period of time with the severity of the punishment remaining unchanged. The ratio is in Vasram Gagji versus State of Gujarat 1992. Rejection of parole leaves shall not be admissible if it is violating prison justice. तो ये कई जजमेंट्स है और भी जिसमें ये कहा गया, जैसे किशन लाल वर्सेस स्टेट ऑफ दिल्ली 1976, A conditional release of a prisoner who has served part of period for which he was condemned to jail, often under the supervision of a parole officer who has served part of the term for which he was sentenced to prison. ऐसे कई जजमेंट्स हैं, तो रिलीज़ करना नहीं करना पेरोल पे, या क्या रूल्स एंड रेगुलेशन दैट हैज़ टू बी फॉलोड बाय डिफरेंट स्टेट्स, और व्हाट rules have been formed by different states about releasing a person under parole is jurisdiction of that particular state. Most important consideration that the releasing authority will always keep in mind is that the right to be released on bail or furlough, as the case may be, upon fulfillment of other condition is not lost simply because the prisoner is unable to post a security bond due to his financial situation. इस विषय पे एक लैंडमार्क जजमेंट दिया है अपने सुप्रीम कोर्ट ने. ये चरणजीत लाल वर्सेस स्टेट ऑफ दिल्ली 1985 है. डिटरेंस, प्रिवेंशन, रिट्रीब्यूशन एंड रिफॉर्मेशन आर द 4 बेसिक गोल्स दैट ए स्टेट होल्ड टू अचीव बाय पनिशिंग एन ऑफेंडर. लाइफ ऑफेंडर्स should be considered for periodic release from prison, and opportunities should be provided for them to not only handle their personal and family problems but also to retain their ties to society. They must be allowed to breathe fresh air for at least a short period of time, provided that they maintain good behavior throughout their confinement and show a want to amend and become good citizens. While they are serving a sentence in jail, the redemption and rehabilitation of such inmates for the good of society must be given fair consideration. This is the judgment, which is the landmark judgment on parole issue. This is the judgment which gave certain guidelines to the states and the judiciaries while considering the petitions or considering representation by the detainee. And main goal of the parole or objectives of the parole is, if the prisoner or any family member is severely ill or dead, when the temporary release of the prisoner is necessary for the plowing, sowing or harvesting, carrying out any agriculture profession, or his father's undivided land is actually in possession of the prisoner, the marriage of the prisoner, his son, daughter, grandson, granddaughter, brother, etc., when it is desirable to do so for any other sufficient cause, according to 2010 parole guidelines, the following requirement must be fulfilled to become eligible for parole. A convict must have served at least 1 year in jail, excluding any time spent for remission. The prisoner must have good behavior during the course of the punishment. The conviction should not have committed any crime during the period of parole if it was granted previously. The convict should not have broken any rule or regulation in the previous parole. A minimum of 6 months should have passed since the previous parole was terminated. और अपने इंडिया में पेरोल्स आर ऑफ 2 types. One, custody parole and regular parole. Custody parole is the type of parole granted to prisoners who are not eligible for regular parole. Come under trial prisoners category. Parole may be granted to the criminal by an order in writing issued by the superintendent of the prison and to under trial prisoners by the trial court concerned for a period of not more than 6 hours. तो ये 2 लोग दे सकते हैं, एक सुपरिटेंडेंट ऑफ द प्रिजन और अंडर ट्रायल रहा तो ट्रायल कोर्ट. डेथ ऑफ ए फैमिली मेम्बर, मैरिज ऑफ ए फैमिली मेम्बर, सीरियस इलनेस ऑफ ए फैमिली मेम्बर. अकॉर्डिंग टू द रूल्स ऑफ prison, it is clear that under trial prisoners can only be granted custodial parole for a period of 6 hours. 6 hours के लिए दे सकते हैं. ये एक जजमेंट है इस विषय में कि अंडर ट्रायल को 6 घंटे तक देना है या था कितना टाइम उनको परमिशन देना है फॉर पेरोल बोल के. ये इलेक्शन कमीशन ऑफ इंडिया वर्सेस मुख्तार अंसारी Honorable Court confirmed that custodial parole is not a substitute for a grant of bail and can be extended for long period than time or daily. What is regular? एक और पेरोल आके रेगुलर पेरोल है. रेगुलर पेरोल क्या कहता है उसके ग्राउंड्स? सीरियस इलनेस टू ए फैमिली मेम्बर, क्रिटिकल कंडीशन द फैमिली ऑन अकाउंट ऑफ डेथ और एक्सीडेंट, मैरिज ऑफ अ फैमिली मेम्बर और कन्विक्ट, delivery of the wife of the convict if there is no one else in the house, serious damage to life or property of family members caused by natural calamities, to maintain family and social ties. These are some of the grounds on which द पेरोल्स कैन बी ग्रांटेड। तो यहाँ अपने इंडिया में दो तरह के पेरोल है, एक कस्टडी पेरोल है, एक रेगुलर पेरोल। कस्टडी यानी वन हु इज़ इन द जुडिशियल कस्टडी ड्यूरिंग द कोर्स ऑफ ट्रायल, एक हु इज़ कन्विक्टेड एंड इन जुडिशियल कस्टडी बिकॉज ऑफ कन्विक्शन एंड टू परस्यू द फाइल। इवन सुप्रीम कोर्ट में अगर ही इज़ फाइलिंग एनी लीव पिटिशन, ही कैन बी गिवन पेरोल फॉर फाइलिंग सच पिटिशन। और अभी इससे पहले मैं आपको इंडियन लॉ के बारे में बताया कि 1900 एंड 1894 में ये कानून बना था कि गवर्नस प्रिजन रूल्स लेजिस्लेशन बनाया गया था, जिसमें ये कंडीशंस है। और इवन स्टेट गवर्नमेंट अंडर सेक्शन 59 क्लॉज 5 ऑफ प्रिजन्स एक्ट 1894 रेगुलेशन फॉर द मैनेजर ऑफ प्रिजन्स अंडर 7th शेड्यूल ऑफ द कॉन्स्टिट्यूशन इज देयर। तो ये एप्लीकेशन कन्विक्ट फाइल करके, वन हु इज़ अंडर द ट्रायल ही कैन फाइल पिटिशन बिफोर द सुप्रिटेंडेंट ऑफ GL अथॉरिटी एंड द कोर्ट कंसर्न वेयर द मैटर इज पेंडिंग। दूसरा आके वन ही इज़ कन्विक्टेड एंड इज़ अंडरगोइंग सेंटेंस पीरियड, he can file a petition before the superintendent of prison. If the petition is rejected by the superintendent of prison, he can file a writ petition before the Honorable High Court or Supreme Court challenging that particular order, where the court, by going through the petition or the rejection order by the concerned authority, they can allow the petition or can grant a order by giving certain conditions. That is the jurisdiction of the court. And if due to some reason he is default or violating the parole period, what is the next step or what is the punishment to that particular person? It is according to section 224 of Indian Penal Code 1860, a convict who overstays parole or does not return to prison within the stipulated time is liable for imprisonment, which may extend to 2 years, fine and or both. This is the punishment or penalty for the person who is released on parole and violates such order. He will be punished for this under IPC. So just now you may see that I have stated about the conditions of parole and the different judgments of different high courts and the rules. Those are governed by different states with regard to Prison Act, and what are the required conditions which are very much important, and whether the parole is a right of a citizen of India or any country, whether he, when he is in conviction period, whether he can ask for release for a particular time because of any emergency, whether the petition can be entertained by the superintendent of prison. That is the issues which I have stated below just now. And even in certain judgments also, Krishna Iyer, justice in a case Babu Singh and others versus state of UP, stated that unrelenting isolation in the harsh and hardened company of the other inmates leads to a slew of unmentionable vices. Therefore, humanizing parole periods are an important aspect of our system's compassionate constitutionalization. This is one of the point by the Justice Krishna Iyer stated. And coming to other aspect about parole, as said, parole is a rehabilitation procedure that aims to change the qualities of such people. The goal of this correctional approach is fulfilled if the delinquent demonstrate that he can change. That is the main criteria. Always and will stop criminal action that are harmful to the community, as well as if he displays an overall improvement in his character and behavior. This is somewhat very important. As a motivation for prison inmates to change their ways, ensure that the prisoner's family relations are as intact as possible, as they may be prone to fracture as a result of the prisoner's protracted confinement. Assist the offender in gradually assimilating into society and adapting to its folds. This is what Prison Act says, and the rules, regulations, and the types of parole in India, and the condition under which the petition for parole can be allowed, or the condition which one has to fulfill So friends, these are the things which are very much important. If you want to file a petition for parole, it is the appropriate authority is superintendent of prison and the state government which has to consider that petition. If those people are rejecting your petition, you can avail the grievances before Honorable High Court by filing a writ petition. And even if those who are under trial, they can file a petition before the trial court and can apply for parole for a limited period. If he is a convicted, he has to file before the superintendent of jail authorities or jail. This is the case with regard to parole. And if anyone is convicted and undergoing conviction period, he can apply for parole. Those are the conditions which just now I told you. And you can avail the petition, you can avail the parole by filing petition before the appropriate authority and can release if the emergency is there. Thank you very much, friend. My name is Srinivas.